Hello, Colorado Realtors. I'm Scott Peterson. Thank you for joining me for another incredibly special edition of Legal Bites. As I mentioned in our last Rethought episode, on the road, out of the studio, we are here at Niagara Falls, beautiful Niagara Falls. Guys, I had never been here before, but it is truly magical. And you're gonna love our next destination, which I'm gonna announce at the end, so hang in there. But I gotta get out of here. It's a little too noisy right here for me to do this properly. So let me get to another location, and that way you can hear this great information that I'm about to give you. All right, guys, I had to get away from the water. I was getting misted and sprayed. It was nuts, and I was concerned you wouldn't be able to hear me. In our last episode of Legal Bites, what I talked about was some of the changes that were to the MLS policy, the Clear Cooperation Policy, NAR's Clear Cooperation Policy. And I explained the implications of that, I think, are probably going to lead to more office exclusives. And what I promised you as well is that I'd be coming back to talk to you about how all of this sort of dovetails into the Division of Real Estate and their perspective on this thing. Because honestly, we haven't heard a lot about this concept of limiting the buyer pool for a number of years because we didn't have any more coming soon listings and we didn't have much marketing. It was ever since the Clear Cooperation went into place, the Division of Real Estate has been able to kind of stand on the sidelines and not worry about some of the issues some of the concerns that they had about coming soon listings and pocket listings and such, because the MLS rules didn't allow it. And with these changes to now the Clear Cooperation Policy, I think we're going to see a bit of an expansion. So I want to revisit the Division of Real Estate's perspective because there is some overlap and some dovetails. As I mentioned, the Division of Real Estate is a consumer protection agency, and they're concerned about limiting the buyer pool. So a listing broker doing something that might limit the pool of potential buyers that a seller might encounter during their marketing process. And if you want more information on limiting the buyer pool, you can look at Commission Position Statement 26. But essentially, in a situation that they talk about there would be like a coming soon listing where there's, my goodness, the falls are they're echoing in the background. If you can't hear them, they're still loud, but we'll get through this. The commission concerns themselves with a coming soon listing where you might put a sign in the yard. And that's not going to happen now. But with office exclusives and the one-to-one marketing policy employed, we might see this increase in some of that kind of pocket listing type marketing. The Division of Real Estate might be interested in limiting the buyer pool because you're going to offer different commission structures to out-of-market brokers or something like that. Or maybe you're going to discriminate against certain buyer brokers or be hesitant to try and do deals with them because they don't use the same form software as you happen to use. And so it makes the deal more difficult for you. But at the end of the day, in any of those situations, your seller doesn't really care. They're concerned with selling their property. That's their primary concern. That's what they've engaged you to do. So limiting the buyer pool is what the Division of Real Estate's worried about. And to the extent that through an office exclusive listing, you are doing that and the seller isn't fully informed and fully aware of that, then you run the risk of violating Division of Real Estate's law, commission rule, perspective, and license law that somehow, to the detriment of the seller, you've limited the pool of buyers that a seller might end up seeing. And remember, it doesn't matter whether you're a TB or as an agent, either of these would apply. If you're a TB, you're obligated to provide reasonable skill and care. Or if you're TB or an agent, you're obligated to provide reasonable skill and care. And that would be marketing as aggressively and broadly as possible for the benefit of your seller. And of course, if you're an agent, you also have to promote the interest of the seller. And from their perspective, to the extent that you're limiting the buyer pool and harming the seller without their full information and knowledge, then you could have issues then with the Division of Real Estate and some of the policies that they articulate under Commission Position Statement 26. Okay, so it's this point that Clear Cooperation Policy and Colorado license law really kind of come together, because whether you're working through the Clear Cooperation Policy and your MLS policy expectations or under license law, what either of those two contemplate is that a seller is fully informed of the marketing plan, that they completely understand the benefits and risks of using any of the marketing strategies that you may employ on their behalf, whether that's the new delayed marketing exempt status, whether that's an office exclusive status, or whether that's more of a conventional active status where the property is broadcast out to the broadest potential pool of buyers. whatever decisions you and your seller are making, the seller ultimately needs to be fully informed and very clear on the decisions that they're making. And that's going to include, for the MLS purposes, their signature on a very robust, clear disclosure that they understand the implications of taking a policy or adopting a policy that is different than a conventional active status, including office exclusive and including the delayed marketing exempt status. So if your seller isn't fully understanding of the implications of that, then you run the risk of not only having Colorado Division of Real Estate regulatory implications, but also MLS policy violations. And so everything needs to be done with the seller's best interest in mind, rather than the broker's best interest in mind. And ultimately, at the end of the day, whether you're working under MLS policy or whether you're working under Colorado Division of Real Estate license law or commission rule, that's a simple question. Is what I'm doing here in the seller's best interest, or is what I'm doing here in potentially my best interest? And if it's the latter, then you need to rethink your strategy in some ways. All right. Well, I hope that sheds some light on the differences between clear cooperation and clear cooperation policy and Colorado Division of Real Estate rule. And I got a new announcement. We're on the road again, and this time we're going international. For the very next edition of Legal Bites, Monica and I are headed to, you're not going to believe it, Zurich, Switzerland. I mean, it's a long way, but I'm told it's worth it, and I'm very much looking forward to getting to Switzerland and bringing you the next edition of Legal Bites. We'll see you again. I mean, it's pretty, but I thought they were bigger.